Very good evening to you, ladies and gentlemen. We warmly welcome you to Tax Talk for another interesting episode. In Tax Talk, which is run by and hosted by Ranaweera Associates, every week or rather every month when we have the Tax Talk, we have a new topic which is current and relevant. And today also we have a very relevant and important topic which is very much related to what's happening around during these days. So without any further ado, let me welcome Mr. Athula Ranaweera, who is the Managing Partner of Ranaweera Associates, to introduce today's topic. A very good evening, Mr. Ranaweera.
Very good evening to everybody. Yeah.
Yes. So, Mr. Ranaweera, let me just quickly talk about today's topic. So, today's topic actually going to discuss and talk about legal and financial relaxations provided to the COVID affected through the introduced Temporary Provision Act for COVID-19. And also, we might have time to talk about the Central Bank of Sri Lanka's recent circular, which is the financial relaxations to COVID-19 affected businesses and individuals. So, Mr. Ranaweera, can you tell us a bit about this? Can you introduce this topic and talk about it?
Yeah.
Mr. Ranaweera, if you have any slides, I don't see it at the moment. Okay, I think it came and went. Right. Let me put the slides.
Now it is. I think that now it is visible. Yeah.
Now it's visible.
Now today we are to discuss about the COVID-19 Temporary Provisions Act. Now, very recently they passed a new act called COVID-19 Temporary Provisions Act. Then we will discuss about this act, as well as we will with the availability of time circular with relate to interest financial supports for the COVID affected people. First, we'll start with this COVID-19 Temporary Provisions Act. Now, in this, now if we'll take this Temporary Provisions Act, now this is in mainly to delay some actions. Suppose you were supposed to do something on a certain date under a law and you couldn't meet that target date as a result of COVID, then if it is the situation, to give some excuses for those people. That is the main idea behind this law. Now, in relation to situations where provision situation, then in that case, to give some excuses for those people. Then, under this act, this excuse period is 1 year. Any act which is to be done during the 2 years period starting from 1st of March 2020, then if you couldn't meet the target date as a result of COVID, then you can get it postponed for some time. Then this 2 years time period, if the minister feels that it is better to postpone, because nobody knows when the COVID will be over. As a result, there's a room for the minister to extend this time period for another 2 years. For another 2 years. That means now if we'll give this next 2 years, almost it will come to about 4 years, right? Then that is the main coverage of this COVID-19 Temporary Provisions Act. Then the Central Bank circular, the circular number 8 of 2021, what they have issued on 1st of September 2021, that is to give further affected with COVID situation, the persons affected with COVID situation. Then, meanwhile, very recently, the finance also passed in the parliament on 7th of September. But we don't have, today we don't have time to discuss about the Finance Act, but we'll be covering the other two, the COVID Act as well as the Central Bank Circular. Now, under the COVID Act, if we'll take the COVID Act, there are four main parts in that. There are four main parts in that. Relief for inability to comply with the prescribed time period. Then, next section in that is the designation of certain designation of alternative courts. Now, sometimes because of this COVID, certain courts may not be in a position to function. Now, in a case like that, they can designate their cases to another courts. Then the third part of that, conducting court proceedings using latest technology, communication technology, remote tech, like online systems. Then the fourth part is with relate to the general things with relate to this particular act. Now, today we will be discussing all these things. Right. In order to save little time, I will cover the next first part 1.
Yes,
Relief
I think it's
for
better, Mr.
inability.
Ranaweera, if we
Yeah,
can talk
because we
about
have,
part 1.
yeah, we have limited time. Right. Relief for inability to comply with prescribed time periods. Now, in different laws, there are various prescribed time period to fulfill various tasks. Now, because of the COVID, suppose a person couldn't meet these targets, through this COVID-19 act, they get some excuses. Now, we'll see what are those things. Now, under this, it says where any court, tribunal, or any authority established by or under law is satisfied that a person was prevented from doing any of the following activity due to the COVID situation. The period within which such person was subject to COVID-19, as a result of that, then he'll be excused for some time. Now, we'll see for what type of actions he'll be excused. The A, instituting or filing any action, application, appeal, or other legal proceedings. Now, in the English word, it says action. In the singular act, which prevail, says naduak. Naduak, the singular, the English translation is not correct here. Therefore, we have to take it as naduak. Right. Then, application, illimak. Then, appeal, abhihachanayak, or other legal proceedings, any niti krutya, as the case may be within the period prescribed by law for such purposes. Now, a person couldn't meet a deadline on these things. Then, performing any act which is required by law to be done or performed within the prescribed period. Any act, perform any act. Right. Now, in a case like this, now for these two types of incidents, they get the immunity. Right. This act shall be operation for 2 years commencing from 1st March 2020. Now, this act, the government thought that the COVID will be able to manage, finish off the COVID within 2 years. Therefore, they have covered this law for 2 years starting from 1st March 2020. Right. That means this is valid up to 28th February 2022. However, if the minister wants, can extend it for another 2 years maximum. But another 2 years, that means altogether closer to 4 years, he'll be able to, with that extension, it will be almost 4 years. Right. If he'll extend. Now this extension was valid for these activities. There are 4 activities they have mentioned. Therefore, aforesaid reliefs shall not apply in relation to the following things. Now, these are Supreme Court, certain cases, Supreme Court, then Court of Appeal, certain things. But I have given the detail, those rule numbers and the dates and all, gazette notification numbers and all. Now, for those things, those 4 things, this particular new law is not applicable. Then aforesaid relief shall not apply in relation to the application of or appeal to any to which the Supreme Court rule or Court of Appeal rule may not be made under this Article 136 of the Constitution of the country. Right. Now, for that also can't grant any excuses of this time extension. Other than those those cases, all the other things, this law is applicable. For any law, any target date under any law, other than these few. Then I have given some remarks. Unfortunately, the following important words or terms or statements given in section 2.1 of the Act are not defined or explained in the Act. Now, these things, the person. Now, if you see the first slide, slide number 4. Now, it says a person. These reliefs are there for a person. Now, we should know what is the meaning of the person. Now, under the Inland Revenue Act, person includes any individual and a corporate or unincorporated body, entity. But here, they have not defined the word person. That's a big weakness in this law. Then the other thing, it says the period within which such person was subject to such COVID-19 circumstances. How to decide that? It is very difficult to decide this second thing. The mode of the way of defining is not there. That's a weakness. Then we'll move forward on this. If ordinary functioning, now this is the second part 2 of the law. Now I said the part 1 is with relate to that extension of time period of the target dates. Part 2 is to assign to alternate courts. Now if there's anything which where the court is affected with COVID, we'll say an employee of the court, that particular court is affected with the COVID as a result, that particular court can't function. Now, in a situation like that, those cases could be assigned to another court by the authority, Judicial Services Commission. They can do that. Then the original, we can call the original court and the designated courts. Right. Now, there are any action, prosecution proceedings or matters filed in or considered by the original court or any new action, prosecution proceeding or matters filed shall be considered or heard by the designated courts. Right. That means some cases may have already started. Those are also could be assigned to another court, and new cases could be assigned to another court. But certain limitations are there. Now we'll see what are the limitations. One is if the original court has reserved such matter for judgment. That means they have already completed the hearing of case and already they are drafting the judgment. If it is the situation, it is useless to assign it to another court. Therefore, it says in a case like that, can't assign to another court. Then the second thing is, if if all hearing is completed. In a case, all hearings are completed. If it is the situation, again, you can't assign that to another court. Then, upon resumption of ordinary functions. Now, we'll say court was closed for 3 weeks. Again, they restarted. If it is the situation, they can take back those cases from the secondary court. They can take back to the original courts. But even in this case, there are two limitations. The limitations are like this. The designated court has reserved the such matter for judgment. That means the designated court has announced that on such and such date we are giving the judgment. That is that stage. If it is the situation, it is useless to refer it back to the original court. Therefore, they can't do that. Then the second thing, this designated court has already completed the hearing of that case. If it is the situation, it is useless to go back. Therefore, that is also limited. I think I have explained the part 1 and part 2 well.
Yes, Mr. Ranaweera. So in that case, shall we go into part 3, which is using, I think, remote communication, which is an encouraging thing to hear, because now they are allowing use of remote communication facilities, I think, for court activities.
Yeah. Yeah, that's now, Yasas, in order to save time, I will continue the part 3 as well as part 4 together. Right.
Sure.
Part 3. Now, this is a good sign. Now, with these lot of barriers, now we started doing lot of our day-to-day work on online basis. Now we are used to that. Now, even this webinar series is a result, is also a result of that. Likewise, now it has extended to the courts level also. That's a good sign. Now, what it says under this act, the COVID-19 Temporary Provisions Act, they are giving the permission to courts for them to have their activities online. We'll read it and see. Notwithstanding anything contained in any other written law, where the following things happened as a result of COVID-19 circumstances. Following things happened. What are the things? Any action, application, appeal, or other proceedings before the original courts may be conducted by means of a live video. It has to be a live video or live television link created using remote communication technology. Not only the voice, it has to be with the video, because otherwise there might happen malpractices. Therefore, it has to be either live video, live television link. Through that, they can activate their day-to-day course activities, communication technology. Right. Now, it says where the following things happen. Now, what are the things covered under this? Any person is unable to appear to the courts. We will say, I am supposed to appear in the courts, but I am suffering with COVID. Now, if one of my family member is suffering with COVID, as a result, I can't go out. If it is the situation, I can, now if the court wish to, they can ask me to participate online basis, online video facility basis to hear that case. Any person is unable to appear in the court. Or the proceedings of the court cannot be conducted under the ordinary procedure. Now we'll say the clerk of that court has got COVID. Now they can't operate the courts. If it is the situation, without opening that court, the judge can hear this case through live video or live television facilities. Right? Now, the COVID affection may be to another person or to the courts. Either case, the court can decide and go ahead with online system. Then, The provisions of this the provisions of the following rules to be applied. These rules to be applied to the extent it is possible that required changes, subject to required essential changes in relation to the action conducted before any original court under section 3(1) of the Act. Right. Now we'll see what are these things. The Supreme Court, now electronic filing and urgent digital virtual hearing. Then next item, the Court of Appeal. They are also electronic. Any other Supreme Court rules. Now with relate to these things also, now it is covered subject to small amendments, changes. Subject to those changes, they can go ahead with that. Right. Now I'll move to the part 4 also to save time. Now part 4 of this law. Now we said the part 1 with relate to extension of the time. Part 2, assigning one court to activities to another courts. Part 3, online court activities. Part 4 is a general thing common for all these previous three items. Now, what are these common things? It says limitations on relief under this Act. There are some limitations. It says the period excluded as relief under the section 2 shall not exceed 12 months. Now the section 2, the first section of the section 2 says it is extended for 2 years. 2 years from 1st March 2022 to 28 February 2022, 29th February 2022. Right. But for a specific for a person can enjoy, even that period is 2 years, a person can enjoy maximum of 12 months period. For his case, he can enjoy maximum of 12 months period. Suppose I was supposed to file a document on 1st of January 1st of January 2020, I can get it extended up to 31st December 2020, only 12 months. Right. However, if that authority, that is authority mean the court, tribunal or other authority wish to, they can extend that 12 months period up to 18 months. For that, I have to apply and get the permission from them. If I'll get the permission, I'll be able to enjoy not 12 months, 18 months. Then burden of proof. Now, when we are doing these things, now there are certain things which we can't decide. What is COVID circumstances? How it is affected? And there are issues in this, as I mentioned. Now, the burden of proof of the inability to comply is with the person who is applying for it. Suppose I am the one who is applying 12 months extension, I should prove the reason why I couldn't do that on time. The burden of proof is on myself. Then the next thing it says, any guidance, direction, circular, notice or decision made by the government in relation to COVID-19 circumstances shall apply. Now, the government can announce various things with relate to COVID-19. Those things we have to take as a guidance, direction, circular or notice or direction without further proof. We need not to search any proof for that type of activities. Then the next one, government. The word government is defined in this law. The word government is defined in this law. But as I mentioned earlier, unfortunately, one of the key terms in this law of person is not defined. That is not defined in this law. I think, Mr. Asas, I have completed the COVID-19 Act, Temporary Act requirements.
Yes, Mr. Ranaweera, thank you very much. So I think what we are left is basically the central bank new circular, which is for financial relaxations to the COVID affected businesses and individuals. If I'm correct, I think the circular goes as number 8, 2020, which is dated 1st September 2021. Can you cover a bit about those relaxations as well?
Yeah, with the availability of time of 10 minutes, I'll try my best to explain that part. Now, the central
Sure.
bank has issued a new circular on 1st September 2021 with relate to various facilities. Now, can you remember earlier, the central bank earlier gave various Saubhagya loan scheme at the rate of 4% interest and all. Those are orders because the government refinance that the government borne the cost of those concessions. But this time, this is not an order, this is a request to the banks, because this time government is not going to bear the cost of these things. As a result, they can't give orders, they are requesting the banks to follow these things. As a result, we can't enjoy that type of a very low interest. We have to, we'll be getting at a higher interest rate. Now, what this law says, the circular is number 8 of 2021. Now, if you'll take this, licensed bank shall differ recovery of capital and interest up to 31st December 2021. That means, suppose this particular borrower is suffering with COVID effects, then the financial effects, then the loan and capital repayment, loan capital and interest payments could be deferred till 31st December 2021. Could be deferred. Now, then how to decide that he has affected? Either loss of job or loss of salaries, right? Loss of job or loss of salaries, or reduction or impairment of business activities, things like that. Then B, licensed bank shall prioritize the accommodation of this facility. This facility, it says, first you have to give these facilities for the micro, small, medium enterprises. Micro, small and medium enterprises, first you have to give the priority. That's good sign. Then it says the deferment of capital and interest both shall be granted for one or more of the existing credit facilities. Now, there may be several credit facilities, then you have to give these facilities for all financial facilities. Right. Then deferment, what is the deferment? Now they have divided this into two categories: performing loan category and non-performing loan category. First, we'll run through the performing category. Performing category, whatever the loans as at 1st September 2021 could be deferred till 31st December 2021. Right? That is the first thing. Right? That is, you can get it deferred, the capital and the interest. Then it says by deferring, now there's an accumulated interest and an accumulated interest and a capital. What you have to do that? Now it says you have to total up those things and give a grant a new loan. Then on the new loan, you are supposed to charge interest of 1% plus the treasury bill rate, which was there as at 31st August 2020. The rate was 593 plus 1%, the rate is 693. Therefore, for this, the new loan occurred as a result of this deferment, the bank will charge you maximum of 6.93%. That is the maximum, right? That is one limitation. Then the loan, whether it is rupee loan or the rupee loan or foreign currency loan, no problem. Then it says the 6 months commencing from now, you are getting now in the case of installment of loans, including lease facilities, the licensed bank and respective borrower need to agree on a repayment period of 6 months. Now this new loan, there should be a repayment payment. It is to be repaid, that new loan component to be repaid. Old loan you have to continue to repay after 31st December. But new loan, you have to repay within 6 months starting from 1st July 2020. 1st July 2022. Right. Borrower shall commence repayment of existing facilities. Existing facilities from 1st of January 2022, he has to start. That means existing one from 1st of January 2022, the new loan 1st of July 2022. Right. If borrower requests for a period beyond 6 months, it is up to the bank to reconsider and approve it. Then to encourage the borrowers to commence the early repayment, now always the bank should encourage the repayment, early repayment. For that, this on repayment of early settlement fee to be waived off. If there's any early settlement fee, you can get it waived off. Then alternatively, licensed banks may restructure the existing credit facility. If there are any existing credit facilities to be restructured, it is up to the bank to restructure it, depending on case by case. Then licensed bank shall be extended the due days of revolving credit facilities. Due date of revolving credit facilities also till 31st December 21. Then penal interest should not be charged up to 31st December 21. No penal interest. Then now suppose I'm supposed to pay the installment by today. I can request the bank and get it extended by maximum of 15 days. Another grace period of 15 days is there. Then licensed banks shall reschedule, they can reschedule after considering case by case. Licensed banks shall waive off the penal interest. The penal interest to be waived off for the past period. Then at the same time, the bank shouldn't take any recovery action. There are some dates given for these things. Then those subsequent few items are for non-performing loans. Now these are for non-performing loans, right? Then number 3, shall not levy excessive fees. Banks shouldn't charge excessive fees. Any check where the value is not more than 500,000 rupees, the valid date to be extended. Then for check returns shouldn't charge additional fee. Then shall discount in the late payment fee, discontinue the late payment fee. Now of credit card, if you will settle the credit card with some delay payment, shouldn't charge late payment fees for that period. Then the licensed bank are required to seek necessary guidelines if they want necessary guidelines to be obtained from the authorities, mainly from the central bank. At the same time, deadline for submission of request. Now, when we have to apply this by 21st of this month. For that, no sooner the bank received this circular, that is 1st of September, by 3rd of September, they were supposed to circulate it among the branches. Then from that day, within 7 days, right, that was there. Then the borrowers should apply this facility before 21st of September this month. Before 21st of September. If you have anything, please apply before 21st. Suppose you delay to apply, it is up to the bank to consider the application or not, right? The eligible borrowers who has the capacity of payment, allow them to pay, right? Then licensed bank shall ensure the borrowers are made aware. Now, this restructured things, you have to educate the customer. You can't just do whatever you want. You have to educate the customers. Without educating, you can do nothing. Then deadline for submission of request. The license bank may inform applicant. Now suppose I applied, the license bank is refusing that. Then within 14 days, they have to inform me. The reason they have to inform, but at the same time, I am permitted to appeal. I am permitted to appeal. Right. Next, license bank shall account how they shall account these transactions according to the previous circular, that is circular number 9 of 2020. Then license banks need to make adequate impairment charges, that is in their accounting matter. Then if they want any guidance, they can obtain this guidance from Institute of Chartered Accountants or their auditors. Then reporting requirement. Now they are supposed to submit monthly reporting to the central bank. Every month reporting on or before 15th of the subsequent month, they are supposed to inform to the central bank. Yeah, so that's all in this, because with greater difficulty I managed the time.
Thank you very much, Mr. Ranir. It was like a marathon as a sprint. So
Yeah.
really appreciate your time and effort in putting across these important updates, because I think it's very important for those who are especially affected by COVID-19 as businesses and individuals. So if you can get in touch with Mr. Ranaweera in the contact details you see on the screen. Also, don't forget to follow Ranaweera Associates on Facebook and keep subscribing the YouTube channel so you can watch the future videos as well. So with that, we kind of end today's session of the Tax Talk. We hope you will connect with us for the next session, which will happen towards the end of this month or early next month. So wishing you all a safe and good day. We would end today's session. So thank you very much, Mr. Ranaweera, for your time.
Okay, thank you. I would like to thank everybody for the participation. At the same time, I would like to mention two things. One is this now there's a opening of this. Recently, they passed the Tax Amnesty Act. We will take that as a topic on a future session. At the same time, now this renewable power sector is reopened in Sri Lanka after sleeping for about 10-12 years. Therefore, this is a good opportunity for the people who are looking for profitable investments. The renewable energy sector, that is a new opening in Sri Lanka. With that, I would like to thank everybody for your participation. Thank you.
Thank you very much and have a good day.